Welcome to Just Champions, a podcast by Equitas, which focuses on the prosecution of sexual violence, domestic violence, stalking, and trafficking from the perspective of the prosecutors who handle these cases, the allied professionals with whom they collaborate, and the victims and communities that they serve. I'm Jennifer Long, the CEO and co-founder of Equitas, and a former prosecutor specializing in adult and child sexual abuse, intimate partner violence, stalking, and sexual exploitation. This is the inaugural season of Just Champions, where we will explore the ways prosecutors influence justice and safety through the lens of our guests, who impact safety and justice for victims in ways you may not expect. In this episode, I'm joined by Ron Eisenberg. He's the Chief of Appeals at the Pennsylvania Attorney General's Office. Previously, he served as the head of the law division in the Philadelphia District Attorney's Office. He has also appeared at all levels of a state and federal court system, including the U.S. Supreme Court. Ron, hi. Thank you so much for joining me today to talk a little bit about your career, your experience as an appellate prosecutor, and all the other roles. I mean, I know you well, but I was realizing when I was going to speak with you today, I don't know a lot about how you got to the appeals unit. So this is going to be fun for me too.
I'm happy to be here, Jennifer.
Thank you. Thank you so much.
Thanks for having me.
No, I know we worked together at the beginning of my career when you would never know who I was, but I definitely knew who you were in the Philly DA's office.
And I knew who you were.
But I guess I would say it was our 10 years ago meeting through the American Law Institute and the revisions of the sexual assault code that really reintroduced me to you. And so really grateful for that. And again, really thank you so much for joining us today.
Likewise.
So I'm going to start with a kind of a basic, tell me about your career. How did you become a prosecutor?
You know, I don't remember not wanting to be a prosecutor. When I went to law school, that was, I guess, the dream I had in law school. Everybody else was going the private firm route. And I kind of thought, well, I don't know, maybe I'm supposed to do that. I tried that during law school and, I enjoyed it in certain ways. Did my summer internships, had my offer to be at one of the big Philadelphia firms, but I couldn't put away the prosecutorial bug. So I applied there. They were much later than the private firms, much slower, much more disorganized in their hiring process. In the end, I kept asking for extensions. In the end, they said, okay, yep, you've got a job at the DA's office. I went to the firm and told them, and they said, we've been there, done that. You'll do this for a couple of years and then come on back and we'll have you then. And I thought that might happen, but that was 43 years ago. And here I am, still doing the prosecution thing.
It's funny you say that. And I can still remember where I was when I got the call from Kathy McDonald, like you, who gave the offers at that time. I was sitting in a dorm room. I was, trying to save money in law school. So I was an RA for underclassmen at Penn. And I remember sitting in there, and much like you're right, their offers come later. So you have to, I had a couple of offers that I had to reject before, but
it was nerve-wracking.
It is nerve-wracking. Thinking, for me, how am I going to pay off these loans? But no, it's the greatest day. So I hear you. And then what led you, I guess, into appeals? When you say you went to a firm, I know, okay, good. I mean, I know you. I know you're a good writer. I know what you do now. But or were you a trial prosecutor first? Talk to me about that.
I had no preference coming in, but I think they had a preference. And, I didn't intend this to be exactly a career choice, but I did some of the activities in law school that I guess sort of point you that direction. I was in our moot court competition in law school. We had a big final moot court argument that I was in. And they were able to get, good people. The head of the panel for my law school moot court was Warren Burger, who was the Chief Justice of the United States.
That's what I was going to say. I remember that at Penn. They used to get Supreme Court justices in there.
So,
yes.
So here I am. I was I was 22 years old. I was doing an argument in front of like hundreds of people, and Warren Berger is the presiding justice. So that was pretty cool. But I wanted to. I was open to anything, but I think that the law school career made them think, okay, let's slap this guy for appeals and see how that works out.
Yeah.
And it worked out. And I was there for. I was the youngest person in the out of a group of 20 when I got there. And after a few years, they made me the chief of the unit. I was still, I think, one of the youngest people there. And now, of course, I'm older than everybody I work with.
Yes. Yeah. Yeah. I think we're all in that camp now. It's funny. It goes very fast, very fast. Right. So you're the chief of special litigation center of the Pennsylvania Attorney General's office, right? And I got that title right. Is that correct?
Now they call me the chief of the appeals section, but it's
Okay. Chief of the appeals section.
Same work.
Right. And the head. Okay. And before you were the chief of, Philadelphia. And I think, people, one of the things that I think is so interesting about prosecution, I think, like you said, you couldn't remember anything else. It's not everyone, but a lot of us drawn because you're search for the truth. You feel like you're searching for justice. You're giving or amplifying a voice to some of the most vulnerable in the community. And so you have that piece of it. And then you also have the opportunity to argue, analyze, litigate these really interesting points of law that are so applicable to people's practical life. Not only on a specific case, but maybe the outcome of something you're arguing could have an impact to victims or communities, for decades, years. Can you talk a little bit about your experience with that?
That's absolutely the case. I mean, everything that we were doing at the appellate level. I mean, we have statewide appellate jurisdiction in my state, so that means every decision affects the whole state. So you're literally making law for criminal cases everywhere, and there's a legislature, and they pass statutes, and sometimes we've been very successful in drafting legislation, trying to lobby, get it through, convince people that they should adopt our legislation. But it's a tough process. And we've made a lot more law in practical terms by the appeals that we argued than by anything we've done through the legislature.
Yes, no, and there are some great ones coming out of Pennsylvania. There are probably some, I'm sure there are decisions that weren't so great from the court. And then you have to deal with them and find a path through with them. I'm sure. And, I think back to the ALI. I know everyone was selected in a different way or maybe found out about the project in a different way. Was there something in the appeals you were handling in Philadelphia or at the Pennsylvania Attorney General's office that brought you to focus on sexual violence or brought you to be interested in that issue or domestic violence, stalking, human trafficking? Or how did you gain that expertise?
We handle at the appellate level. We don't really specify by subject or by type of crime, but some of the biggest cases that I worked on happened to be involving that area of the law. It's hard to remember specifically some of the ones that I did 30 and 40 years ago. I mean, a lot of them were murders, and that stuck out for me. But later on, in the office where we worked in Philadelphia, the office started to put a lot of attention, as you know, into the Philadelphia Archdiocese and the clergy sex abuse scandal that was uncovered there. And I was brought into that and spent a lot of time on that matter. And there was appellate litigation that arose out of it after prosecutions resulted from that investigation. There was more than one, actually, grand jury investigation involving clergy sex abuse in Philadelphia, and some other cases that we did that were not specifically about the church. You may remember the Danielle Kelly case, in which a child was abused and died while supposedly under the care of the Philadelphia child welfare process. These were big, all-consuming projects that um, you couldn't avoid drawing your attention to the Gosnell case, the doctor who was performing illegal abortions in ways that actually killed some of the women that he and seriously injured some of the women who were going to him.
Sorry, I forgot about
Um,
that one.
and we this I think, I mean, everybody, murders are kind of obvious.
Mhm.
And some of these other areas were less obvious. And so the development of these investigations and this litigation that really focused on some of those areas was, of course, not entirely a new thing, but I think still eye-opening for people and even for myself.
No, absolutely. I mean, and when you're talking about the clergy abuse, and because there have been so many of these, I might be thinking about some legal issues raised in different jurisdictions. This one actually might have been raised in Florida. But when we think about victim behavior, this question of reporting, oh, why don't people report? Or the statute of limitations, being running and you're not allowed to file these reports. And I remember, this conversation, these arguments about, well, some of the tactics of the perpetrators were to take the victims into the confessional and have the victims confess. And this use of God in a way to really silence people. And I think an understanding of religion, when you understand your own, I mean, I'm Catholic, so maybe I can picture a little bit more what that was like, but just bringing an understanding to how that could reasonably silence someone and perhaps how that might be intimidation. I know I don't remember if those arguments were successful at the criminal level down south. My recollection is that they weren't, but they then serve to educate because people understand how purposeful these offenders were and really how monstrous they were outside of the assault in how they controlled their victims. And that's a large part because of the appeals, because of people raising this and letting people understand what happened.
Yeah.
And I mean,
And
I'm sorry, go ahead.
and you're right. There are a lot of issues, legal issues that arose out of these cases, but also a lot of, I guess I would say, communication and education. The We had investigators and lawyers who were looking into these things, but then to communicate that to the public, we wrote grand jury reports. And they're kind of like writing appellate briefs. They weren't, the reports themselves were separate from the appellate litigation that arose from those investigations, but they were handled by many of the same people. The people who were writing those reports were the same kind of people who write appellate briefs because they involve similar skills. And, trying to convey to the public what was really happening I felt a deep challenge. And, it's almost easier to look back on it now and think, okay, that stuff is all obvious. But I remember when I was writing some of those things, I was thinking, people are not going to believe this. They're not going to believe it's as bad as it is. And I was afraid of going too far, being too sensationalist and trying to convey the reality. But that's because at the time, it wasn't obvious to people that these things happened.
So I had never really thought about the role of a grand jury report outside of the grand jury leading to indictments. And those, you're right, those are public, right? The reports that come out of the grand juries. Okay,
Yes.
why do prosecutors do that, or what's the purpose of that?
They do that in those jurisdictions which provide for it, which are many. They do that in order to convey a larger social problem that the investigation uncovers that may go beyond prosecutions.
Mhm.
In the case of the clergy sex assaults, for example, one of the things that I think the public needed to know, and you've alluded to this, is that in many cases, it's not reported until after a statute of limitations has expired. And that means there's not going to be a prosecution. So the public's not going to learn about the facts through a prosecution because the efforts to cover up were successful. They worked. And people were too scared, too traumatized to come forward. Statutes of limitations were too short in many cases at the time, and so the only way to convey uh, the reality to the public is through this kind of reporting. And there's been some controversy about that, about whether reports can name names and that sort of thing. In Pennsylvania, in litigation that I've been involved in for many years now, the Supreme Court has been attempting to put some strict limits, procedural limits on what can be done in that regard. And we are attempting to comply with those limits and make the case that this kind of public reporting can be done with fairness to all involved and still meet the public's understandable desire and need for information about these events.
Yeah, that's actually, I mean, I had one other question I was going to ask you, but when you're talking, I think about that and the role of the prosecutor, because I often felt, and you've just described it there, I've often felt in trial. I mean, you are the person when you're doing your job, you're there to pursue truth. You're there to reveal truth. You are the person, you're not there to do zealous advocacy. You're not there to rule on legal aspects. You're there to take the evidence. I mean, obviously, when we're in court, we believe a crime has been committed beyond a reasonable doubt for certainty when we're there, and that we have the right person. But our role is such that your job is to do that and to also maintain due process, to also ensure that there's fairness. And I've often said the worst kind of hearings to walk in on are ones where you felt like perhaps a defense attorney was not up to the task, because then you really needed to do the whole scope of your job in one. Your job was to ensure fairness was going on while trying to present your case. And I think that's the part that's lost. Oh, go ahead.
Yeah. And appellate prosecutors in particular have a role there, because we see the effects of those kinds of potential errors. We have to defend against them, respond to them, sometimes concede them. And so our audience is not just the court. Our audience is other prosecutors who are involved at the beginning of the lengthy criminal process, but not at the end. I mean, people think understandably from watching TV that, the criminal trial process it happens and police immediately investigate, and then there's a trial the next week or the next month, and then the trial ends and everything's over. And in fact, the process is so much longer than that. And we have cases that we're still working on that I was involved in when I first started to be a prosecutor. I mean, some of these cases go on that long because they can go on as long as the defendant is alive and in prison. He can keep appealing, basically. I mean, there's no such thing as really a single appeal. And so on the appellate side, we see the long-term consequences of everything that happens at the trial. And so, part of what we want to do is educate our trial prosecutors about which things may or may not be issues on appeal.
So that's fascinating, because you're right. We're reading the trial decisions to figure out how to proceed, what's sufficient, what procedures correctly, and thinking about sometimes, okay, how do we consult? How do we talk to appellate attorneys in the beginning to make sure we're making a strong record? How are we trained by you all? And part of that is I'm understanding now, reading the decisions and your briefs, because you're speaking to us and trying to tell us what to do. So, I mean, that's fascinating. That's great. And it works for those of us who are reading them. And so at the appeal level, I mean, there's no trial testimony, live testimony being given. But still, the victim's testimony, I'm thinking about sexual violence, domestic, any case, but obviously, my focus, I'm trying to think of human trafficking, stalking, sexual violence, domestic violence. When there's no testimony being given at a hearing, how is that incorporated? How does that become relevant? How do you give a voice to the victim in the appeals process?
It's a great question. And I think it's an important one because some prosecutors or some people at large may assume that it's a relatively dry process. The appellate process is a legalistic kind of debate. And I think we have to fight back strongly against that perception. And our approach has always been that it's very important to convey to the appellate court the what really happened below, what it's about. I mean, the facts, they just can't be divorced from the law. As much as people might speak about the appellate process being, a dry and intellectual one, the truth is that every case, I'm not sure people always understand this, every decision by a court of an appellate court is a decision applying the law to the facts of that case. Now, usually those decisions will affect many other cases with somewhat varying facts, but they're always driven by the facts of the individual case. And they are, in our view, they are supposed to be driven by the facts of the individual case. And so, it's very important, I think, for us to speak for the victim who's not there. Not, in the appellate court, the victim's not there. The defendant's still there in a sense. He's not physically there, but all the discussion is about him or her, almost always him in reality. And, he's the subject, the star, the focus of the proceedings, even when he's not physically there. And the victims aren't. And I think it's our job to convey the facts from the victim perspective as well, and not just from the defense perspective, because it's important for the courts to understand the reality of what's at stake. I think.
I love that. It reminds me of that. We quote from this old Supreme Court case. I think it's Berger is the title of it, where the justice, though due the accused, is due the accuser as well. I think Cardozo wrote the opinion. We must not stretch it, to a filament. We have to keep the balance true. And just reminding people, I mean, there are rules too that protect the victim. And
yes,
there's a reason for that.
and the rules are less sort of obvious, at least in the appellate sector. I mean, we don't have a Bill of Rights for victims in the United States Constitution, but there's so much appellate litigation about that. And it's important that all these rights are established for the defense, and that we that they are enforced. But if it were just about making sure that the defendant is never unfairly convicted, then we could easily solve that by not convicting anybody. Yeah. Right? There is a way to be absolutely sure that nobody is ever convicted unfairly in violation of some right of a defendant, and that is to have no trials at all.
Right.
And obviously, that's not what we do. That's not what the criminal justice system is for.
Right.
So those important interests on the other side, have to be addressed by someone, and that's the prosecutor.
No, absolutely. And I think, the worst thing you can imagine is convicting the wrong person. So everything we do to ensure that beforehand and during the trial to make sure that that's not happening. Do you have, I'm thinking, this is kind of a funny, nerdy question, but I'm interested, like a favorite rule of evidence or a favorite legal argument that comes up in these cases that's particularly interesting.
Well, I'll tell you one that's germane to our overall subject. I don't know if it's a favorite because it's been a challenging one to litigate, but that's the role of other crimes evidence.
Oh, yes.
Which can be an issue in all sorts of criminal cases, in murders, in drug dealing, etc. But it's really particularly important and has received a lot of recent attention in relation to sex crimes. So, if I recall correctly, that was the ground on which the Harvey Weinstein conviction was just thrown out. For us in Pennsylvania, the big, relatively recent example of this issue is the Cosby case, which the Pennsylvania Supreme Court ultimately dismissed on other grounds that
exactly
we didn't agree with, but that's the way that things happen in litigation. But the big issue there that they didn't reach, and which is still out there and still coming back, there's another case right now where the court will be addressing this, is other crimes. Can you show that when a defendant says, well, I didn't really do this thing in the way that you're saying I did. For example, this sexual encounter is really consensual. Do you get to show that there were 5 or 10 or 20 other cases with very similar circumstances that begin to make it seem like it wasn't consensual. Um,
Right.
and this
Right.
is, I mean, every layperson, I think, understands the relevance of that kind of evidence. The courts say, yeah, but there's prejudice to the defendant too. And so we've got to be very careful with it, because if they hear that he did the same thing 10 other times, they're going to naturally assume that he did it this time, even if he didn't really do it this time, which
Right.
I get. But again, there's got to be a balance, as you were saying, and it can't be that this sort of evidence never comes in, because it's so probative. Uh, uh, Certainly from a real life perspective, and to some extent, at least, trials ought to be able to reflect an element of common sense and
Absolutely. And,
experience.
it does sometimes come down to the precision of the argument. And this is where, we see this with Rape Shield too, where some of the social science, the qualitative and the quantitative, and I'm thinking about these untested rape kits that are revealing all of these serial rapists that were cross offending against older people and children, and people they knew and people they didn't know, and doing burglaries and doing kidnaps and doing other rapes, these things that seem so disparate. And in fact,
Mm-hmm.
what we were learning from, and Rachel Lavelle, who's a scientist out of Cleveland State now, is really has kind of helped us make sense of how how purposeful, again, how offenders, they learn. They may use a gun, and they may actually learn, you know what, that was a little risky. This didn't really go the way. Next time I'm not going to use a gun. Maybe next time I'm going to determine someone in my sphere that I can intimidate. Someone's maybe addicted. I'm going to learn from what I'm doing, and I'm going to do it differently. I'm going to do it better. I'm going to do my victim selection or my different pieces, or maybe it shows my lack of mistake. It's we have to know. I mean, I'm definitely not one who says, okay, you've done it 20 times, so you did it the 21st, and maybe you
Mm-hmm.
didn't, but we're going to get you anyway. No, but I don't think the law, I think 404 is, or other acts, I know somewhere it's Molyneux, right? That famous Weinstein case you were talking about. It's really about putting the focus on the perpetrator and telling the court why it's relevant, what they learned from this. And again, because it's so appealed, thinking about maybe the different areas where you're allowed to introduce this under that rule, how your arguments may fit. But I agree. I mean, we have to explain that, because the public, I mean, I think the public's even we did. You grew up thinking, okay, serial rapist MO, they have a victim they go to. They have a type of crime the way they do it. Well,
Mm-hmm.
actually, nope, that's not always the case. They really learn. I think one of our John Curland on our staff, he always
Mm-hmm.
called it leveling up, like gaming. Like they're getting better at the game
Yeah.
because they're doing it. But no, other acts, I could talk about that forever, as you have seen.
It's a
So
big issue, both in
it is a
sexual
big
assault
one.
and in other prosecutions.
Absolutely. I mean, you've already named a lot of the Pennsylvania, cases that you've handled. And I was, lucky enough to be familiar with them all. Is there a particular Pennsylvania Supreme Court case that, I don't know, you were involved in, or that is interesting to you for some reason, or maybe from another jurisdiction?
Here's one that it was not the biggest case in the world, not the most dramatic thing, but it really struck me from the sort of the victim centric point of view. We had a case a couple of years ago that we did a brief in, where the issue was comfort dogs in the
Oh,
courtroom. Um, and not everybody is familiar with this, but I mean, people now are used to the idea of service dogs, right?
right.
And some of those are emotional support, not just you know uh, for blind people or whatever. And there's a growing use of dogs, not because the person had their own service dog or emotional support animal that they use in regular life, but just because the process of being a witness after being the victim of a crime is so traumatic, especially for kids
Yeah.
who are victims of crime. And this was challenged by the defense in Pennsylvania on the ground that it's unfair to the defendant, because jurors might see the dog and they'll like the dog, and if the dog is being nice to the victim, the kid or whoever, they'll think that means that that person was really the victim of this crime is charged, and that's unfair. And that's that's a significant issue in terms of a victim's rights, because on the one hand, that might happen. Somebody might like dogs, and if there's a nice dog up there, they think, "Oh, that poor kid." But on the other hand, that victim might be totally unable to express themselves at all, and it could be we've seen this with people on the autism spectrum, etc. Without that support, and it makes a difference. It opens their mouth, let's say, and then it's going to have to be for the jury to assess the credibility of that testimony the way they would with anybody else. But otherwise, the testimony doesn't come out at all, and the defendant gets off, and that can't be right. I mean, there's got to be some appropriate accommodations that are made for the victims. And if the jury's going to feel sympathy, if the concern is that the jury's going to feel sympathy for the dog, well, then the dog's not the problem. The kid should be the problem. I mean, if a child is testifying in court, something pretty bad happened to that kid. And if the jury isn't able to put aside their sympathy for the child and decide the case truly, then the dog's not really the problem. So that was a interesting case for us.
That's a great case. And I know, I mean, not the only place that service dog comfort dogs have been challenged. And it's wonderful to hear you making that case. And I think it's so really just underscored one of the whole reasons for this podcast, really talking about the role of the prosecutor and how they touch so many things. And I feel like you've gone from all these really complex legal issues to, some of the basics about victim rights and people's perception and thinking about common sense and the right for a victim to just feel comfort in a courtroom. You have been, it's been such a pleasure to talk to you. I'm wondering would you encourage law students to pursue a prosecutor career still? Would you have them consider a career in appellate units?
Of course I would, and I know it's not the fashion these days. And I know I've been for many years. We went around to law schools to do hiring interviews for people who signed up, and I know that the fashions come and go, but I do think it's a fashion, and there's an underlying reality that I would hope that law students would remember, despite the kinds of education they might be getting these days about the criminal justice system. And that is, I guess it comes down to this: the importance of the adversary process, the idea that there's two sides. I think that's come under suspicion for law students, and I think that's a big mistake, because people are people, and so it's very hard to be totally objective about your side. So if both of the lawyers are on the same side, you can't really be sure that the full truth is coming out for the judge. I remember, I liked to write, I liked to argue, I liked to think. One of the things I thought about was going into a career in journalism, and I realized at one point, and that, I mean, there's no other side there. I mean, sure, there's supposed to be a marketplace of different viewpoints from other newspapers, etc. Sometimes that happens, sometimes it doesn't happen. But I was uncomfortable actually being in confronting a situation where I was the only side that readers would hear. I didn't want to trust myself to be the only side that people heard, and I don't think that the people on the other side from me should trust themselves to be the only side that people hear. And the thing about the legal process is that in the criminal justice system, there's a judge or a jury who gets to hear competing versions from both sides, and that really matters. And we've been involved in some cases where, I know that progressive prosecution is a byword these days. We've been involved in some cases where progressive prosecutors join with the defense to agree on a position or concede that, certain things had happened. And we've been asked to come into those cases. What we found is that there were some really crucial facts that don't get reported to the judge sometimes when that happens. Things that would
Yeah.
really make a big difference, I think, by anybody's standards to deciding, the proper just result. And you don't always have to believe our version, but you
Right.
have to have a process where both versions can be heard, where there can be a competition of ideas and arguments that expose the flaws and strengths of each side. And so then the question is, if you're at all interested in the criminal justice system, which side are you going to pick to do that on? And there's value and virtue in both sides. But for me, it's just, there was no one else that was speaking up for the victims. There aren't a bunch of law schools and legal projects and nonprofit organizations that are doing things from the prosecution side. Yours is one of the very few, as I'm sure you're aware. So in every big case that, we just filed something in a big case in the Pennsylvania Supreme Court, and there were 17 amicus briefs, friend of the court briefs on the other side. And we were the only one on our side. And that's often the way it is. And I remember being asked about this. I had an argument in the United States Supreme Court. I got to eventually go back after that law school experience with Justice Berger, and I've gotten to argue several cases in the United States Supreme Court. And every time, of course, there's a bunch of amicus briefs on the other side from the prosecution. The big bad prosecution really doesn't have the same resources that the other side does in these cases. And one of the justices said, "Well, how could your position be right when all the amicus briefs are on the other side?" Well, that's because they all had a particular viewpoint, and that doesn't mean they're right.
Right.
It means that there's two sides, and you should really hear both sides.
Well, I can't think of a better way to end. That's fascinating, and I agree. Ron, so happy to speak with you today. So thankful that you spent your time with us in between your brief writing. I know you have another one that you're working on. So thank you so much for spending this time with us, and I wish you a lot of success in this next brief.
Thanks very much. Good to talk with you, Jennifer.
Okay, thank you.